Bach.
Thank you, my Lord. Before resuming the thread of my argument, might I address the questions from this morning as best as I am able? First, the question as to whether there was any particular evidence underlying the threshold of £3,000 as the bottom line for disposable capital. The short answer is there was no science behind that figure.
No science behind?
That figure, yes.
That's a neat way of putting it, Mr. Barr.
It was simply the figure that was thought appropriate, beyond which people should make a contribution to the fees, contribution to the cost of the tribunal. The question about ACAS...
And that, of course, that was borrowed from the general civil rules.
That is, yes, the rules are common.
So the 3,000 wasn't necessarily picked in July 2013. It was inherited from earlier rules.
That I'm not sure about. It is the figure now that applies across the board.
Of course.
I'm told it came later.
It came later. Very well.
Yes. And the question about whether there was any specific evidence in the bundles about which might show the success rates of conciliation before and after the introduction of fees and before and after the introduction of mandatory notification for conciliation. The answer is that we haven't found any. The question about the Hillingdon case and the basis behind the funding, which I took the court to, there is something in that decision. It's Authorities Binder 1, tab 12, at MS 2353, paragraph 13, towards the bottom of the page, is reference there to a consultation paper, and over the page, at the top of 2354, there are 2 bullet points explaining the rationale in favour of charging into departmental services, and I think I'm right in recalling that they were precisely the 2 reasons that the lady mentioned.
Oh. I can't claim to have read those paragraphs.
The final point from this morning, if I'm correct, is the discrepancy between the fees figures that I read out and those submitted yesterday. We think any difference is due to my citing the in-person fees and my learned friend citing the online charges, which are slightly lower.
Thank you.
I'm moving now to the final issue of law before moving on to the facts in relation to ground 1, and that is the test for a systemic challenge such as this. We submit quite simply that the test is whether the scheme is capable of being operated lawfully. The authorities for that proposition are all set out in our case. BB, if you want the references, there it's at file 6, tab 88, paragraphs 2, 69, 50 and 101. They're all set out in our case at MS 166.
So if, hypothetically, we came to the conclusion that your scheme was capable of being operated lawfully, but had not, in fact, been operated lawfully in the last 3.5 years in a significant number of cases, do we do nothing about that?
The Lord Chancellor wishes to comply with the law, and her first submission would be she would, with the guidance of the court's judgment, wish to put matters right, and so we would ask for time to do that. My fallback submission was that it would be for a declaration which would result in
Yes.
my client putting matters right.
Very well. Thank you.
And the other authorities are the Christian Institute case, Binder 5, tab 65, paragraphs 2, 60 and 69, and Lebanon, that's Binder 2, tab 13, at paragraphs 56 and 58. Turning now to the facts, could I start, please, with Appendix 6?
Yes.
I'd like to take you first to the original consultation for the fees order. That is to be found at page 1730 in old money. The equation we have to apply is to add 254. So I think that will be 1984 in new money.
Thank you.
Moving 4 pages further on to the foreword by the then Minister, Parliamentary Under Secretary of State. The aims are there expressed in the foreword in the bottom paragraph.
So what was page 157?
It's in old money, I'm on 1734. On new money,
yes.
I'm on 1988. The reference in that paragraph at the bottom to the 2 sets of proposals is that in the original consultation, there was option 1 and option 2. Option 2 involved a single fee point, and it involved the option of capping the damages you were seeking, and if you were seeking more than £30,000, you had to pay a higher fee. That option was abandoned after consultation. The other option, which was pursued with modifications, option 1, became the fees order that we know, although in its original proposed form it had 3 fee levels, not the 2 to which the court has been taken thus far. As we'll see, the 3 fee levels followed the 3 internal management tracks that are used by the employment tribunals to manage their cases. The most expensive claims to provide facilities for are discrimination claims, and they were in the highest of the 3 bands, and following consultation it was decided to include those in band 2 and not to have a separate and more expensive band for discrimination claims. Could I move now, please, to page 1747 under the old money, which will be 2001, I think, if I'm doing my arithmetic correctly. This is a part of the consultation paper which is addressing the costs of the employment tribunal, and the points which I'd specifically like to draw the court's attention to are, first of all, in paragraph 8, the principle from the Treasury guidelines that was being followed was that users should be charged no more than it costs to provide that service unless there are strong public policy reasons to do so. So there's never been any intention in this jurisdiction to charge more than it would cost to pay for the service. There is a diagram in the middle of that page from which one gets some information about the breakdown of costs, and you get some information there about the fixed costs and the variable costs, which is a subject I can come back to. May I take you over the page, please, to 1749 in old money, and to look at the left-hand page, paragraph 13 and 14, where you see the question of the cost model that was used in the proposals, and at paragraph 14, the fact that there was a financial objective for the level of cost recovery agreed between the Minister and the Treasury. The target, as my learned friend correctly said, was to try and recover a third. That was the working assumption. The specific fraction is at page 1769 in old money, and that will be 2023 in new money, paragraph 115. If I can now move to...
Hold on. Paragraph 115 tells us that the proposed that the fee rates would have achieved approximately 33% of the cost. Does anything tell us how the fee rates were arrived at? I mean, it sounds as if that's the conclusion, rather than that the starting point is we want to recover 33%, and that works out at these fee levels.
I don't think I can readily put my hands on that information. There was a lot of modelling done. Might I take you now to start to look at why some of the other alternative options were rejected. First of all, 1753, which will be 2007 in new money. And at the top of page 1753, we see the heading Alternative Options. And there, the reasons against charging an ex post facto fee are set out. It would cost more to administer. It would not have the same incentivizing effect on alternative dispute resolution, which I made submissions on this morning, and it would require more to ensure that payment was actually made. Instead, the system that was adopted ensures that the money is received before the service is provided. At paragraph 30, the option of more charging points is dealt with. Again, it was thought that that would be more complicated, it would have a slowing effect, and I can leave the court to read the other bullet points.
So, in summary, we've got the cost of the employment tribunals at 1747 to 1748, employment tribunals expenditure in 2010-11.
Yes.
And am I right broadly to total that at 80 million? Seven figures?
I think, broadly speaking, I think that's correct at about that time, and the figures have generally come down over time, so that, as my learned friend said yesterday, they're now down in the 60s.
But from the point of view of this presentation, 80 million is the cost. We want to raise a third.
Yep.
That's about 25, 26 million. But what we don't have is how 25, 26 million results in the particular fees that were then being consulted upon, still less the particular fees ultimately alighted upon.
You
Is
don't
that
have.
right?
You don't have the detailed working in these documents, my lord.
Very well.
That's true.
And indeed, it doesn't look, does it, as if they started with a percentage and worked back to the fees. It looks as if they did the opposite.
I haven't been able to discern
Well,
a different.
115 would strongly suggest that. Here are our fees, and that will produce about 33%, it says.
There's nothing to gainsay that in the documents, my lord.
That's presumably would have produced 33%, assuming the same throughput of cases.
Well, it assumes a whole load of variables, most of which most of the assumptions were not realised.
Yes.
The one that was realised was that the amount of actual money that was taken did fall within the original estimates, but the amount of remissions, which, as you were shown yesterday, is taken into account as assumed income, was very much lower. The principle that expenses are consumed from the start of a case and therefore should be paid for at the outset is to be found at page 1757 or 2011 in new money, paragraph 49. The question which my Lord Wilson posed yesterday about, I think it was my Lord Wilson, about why not charge the defendants at the outset, that's dealt with at paragraph 51.
Yes, thank you.
Yep.
Can I move now to volume 3? We'll come back to 6 in a moment if that helps with bundle management, but I'd like to take you to the response to the consultation to page 784, please. That's 1,000.
784, did you say?
784 old money, 1038 new money.
Thank you. So that's
Appendix 3.
Appendix 3, is it? Yep, it is.
Some impressive mental arithmetic going on here.
And I'm doing it the way I'm doing it so that I only have to add. Yesterday I was trying to subtract, and that was definitely beyond me. The point here is in the response to consultation, at Part D, Alternative Models for Employment Tribunals, we see the response to proposals, including a proposal that each individual within a multiple claim should pay the same flat fee as every single claimant. The potential benefit being that you could impose a lower fee per capita. And the problem, as you will see, especially at paragraphs 212, is that not only are such multiple claims much more volatile than single claims, which would have an effect on income stream and therefore budgeting, but also the fees which would result for the largest multiple claims cases, and there are a lot of multiple claims cases in the employment tribunals, would be colossal. And the hypothetical example given at 212 would have resulted in a fee in excess of £1 million.
Are these mainly equal pay claims?
There are a lot of working time claims. There are a lot of equal pay claims. They're not always, but they tend to be discrimination claims. You sometimes get large unlawful deduction of wages cases as well, although they tend to marry into the working time cases.
Do we have any of the responses, one of which I see came from UNISON Scotland?
I think the responses are, I think the answer is we don't have the actual responses, but I think the responses are summarised within that document.
Is there any prediction of doom?
I think it's fair to say there was considerable resistance to the implementation of the scheme, and that people did warn of deterrence.
Yeah. Paragraph 209 on page 784.
Quite.
I'm afraid I don't have a MS number. But the majority of respondents believe that the proposed fee levels will deter meritorious claims.
Yeah.
Yeah.
And 201.
Almost 90% again, yes.
That's option 2. That's what they ended up with.
I thought we ended with option 1, didn't we?
We ended up with a variation on option 1, a modified version of option 1.
Option 1.
Yes.
Yep.
Yeah. Yes, my Lord has the point that the responses at this point are about option 2.
Yes, of course.
Yes. It's one, you're quite right, it's 179, which is the equivalent for option 1.
No, it's the same percentage, roughly, isn't it?
If I may move now to the question of why there were 2 charging points. This is volume 6 in old money 1752, new money 2006.
Yep.
Paragraph 24, please, which is at the top of the page, the first bullet point. The earlier stages consume less resources than the later stage. And so if a case is disposed of one way or another between the 2 charging points, it saves somebody having to pay for a service which they haven't used. The other big factor that's driving the type of fees as well as the number of charging points, complexity. At paragraph 26, we see the statistic that 80% of jurisdictional complaints, that means causes of action, do not require a hearing. And for that reason, it made sense to have 2 charging points and not just 1. There would also have been more administrative expense and more complexity involved if you had had more charging points, which I think I've already taken to the pay over leaf, which has that.
So what's a jurisdictional complaint? Whether it discloses a cause of action?
It's effectively the Ministry of Justice uses the term jurisdictional complaint in the way that you or I would use cause of action. So there may be one case with several jurisdictional complaints. Moving now to the use of a discretionary power, at page 1755, that's 2009 in new money, the bottom of that page, section 4, who pays the fees? And at paragraph 43, it's made clear that the rationale is that ultimately the person who pays is the person who has caused the dispute to have to go to the tribunal. And then
and that person isn't the person who should have paid the money and hasn't.
So if the respondent loses, the respondent should be paying because they've caused a dispute. The claimant should pay to start off with because they're bringing the claim using the service. But if it turns out they're in the right, then the respondent should pay. And Paragraph 46 recognises that a power will be needed to do that, and it's quite clear from the wording of the consultation that the intention throughout has been that that should be the general rule. The payment of the fee should follow the event, but that there was a need to leave the judge with a discretion.
Yep.
The case which I said I'd take you to on the exercise of that discretion is at bundle A6. It's called Portnick. It's at tab 82. Following the MS page numbers, MS 3945 gives the summary. I think that's all that we really need to go to. Explain that here there'd been substantial success. The claimant hadn't won on all points, but still recovered the fee. There was a slight complication in this case in that the fee hadn't actually been, there was an outstanding application for remission. I'm not quite sure how that had happened. There is a provision to apply for reimbursement, and it may be that that was being used, but subject to the remission issue being resolved, the substantially successful claimant was going to recover the fee. Moving now to the question of why use two fee levels, if I could go back to Appendix 6 and page 1754 or 2008. And here we see the explanation of the three levels of claim used for administrative purposes within the courts and tribunal services right at the top of the page. Level 1 are effectively the claims which are now type A. Levels 2 and 3 are now type B. And at paragraph 34, the document explains that on average, the higher level cases use more resources, they require more case management, more pre-hearings, and have longer final hearings. And later on, I'll take you, when we're dealing perhaps with the discrimination point, to some of the figures which quantify the differences and justify the differences in the fee levels. Over the page at 1755, 2009, it might just be worth noting at the top of the page that there are over 60 different types of claim that can be brought in the employment tribunal, which is a reason why it was thought having a bespoke fee for every type of claim would be impracticable. Sticking with Appendix 6, could I go now, please, to 1750 to take you to the, that's page 2004 in New Money, to take you to the reference to the 2007 research, which I mentioned this morning, about the cost sensitivity of court users. It's set out in paragraph 16, and then footnote 18.
What page was that?
Page 1750 or 2004.
Paragraph 16.
16.
Yeah.
And there was a recognition at paragraph 17 that these data may not translate readily to the very different forum of the employment tribunals where fees had not been charged in the past. There was some modelling done about potential sensitivity of claimants to cost, but it wasn't informed by much factual data because there wasn't much to feed into the assumptions. The reference to that is file 3, that's appendix 3, pages 704 and 958.
Do we have the Ministry of Justice research in the footnote 18?
I don't think we have that in the bundle, my Lord. If the court would like it, I'm sure we can provide it.
Well, it might be. Can we find it on the internet? We probably can still.
Well, there is a website, so hopefully it would be. If there's any difficulties, we'll be happy to provide a copy.
Where do you want us to look on 704, Mr. Ford? Is it 414?
I beg your pardon?
Sorry, where on 704 did you want us to look?
17.
No, 704 you said. Appendix 3, 704 and,
Oh, sorry.
and another number you gave us as well.
958.
Now I'm with you. Sorry.
We've got elasticity of demand in 414.
Yes. The very top of the page
Yep.
704.
Thank you.
cannot predict, last line, cannot predict the size of the effect. And the modelling is set out in the paragraph underneath, where there is a low response scenario where they propose that if you lose 0.01% of every pound of fees because people are deterred, you lose so much money. If it's a 0.05% fall in cases, you lose 5 times as much money. It doesn't really go anywhere because it's a model that needs to be informed by some assumptions about litigant behaviour, and I've shown you the data they had, and so it wasn't possible to do any more at the outset of the scheme.
The Ministry of Justice or Government UK website refers you to something which tells you how to change the address on your driving licence. It doesn't seem to have much to do with that research paper.
In that case, my lord, those instructing me will find a copy and obviously send it to all the parties and the court.
We'll send him a driving license. Yes.
Could I go in Appendix 3, please, now to page 665?
Yep.
And this is a table at the top of the page.
Yep.
919 in new money. Thank you.
What are we looking at? Well,
We are now looking at the initial equality impact assessment.
dated?
That is page 892 in new money, 638 is the first page. I'll find the date for my lord in just a second.
It says it's undated.
December,
Yes.
December 2011, I think.
Thank you. Yes.
At 665 is a table which explains how much these cases cost. Fee at full cost recovery is the third column. The fourth column was the then proposed fees. The precise numbers were altered in the final scheme, but it covers issue and hearing fees for each of the 3 levels administrative levels of complaint. If you need a ready reference for those levels, if you turn back one page, you'll find a list. But what you can see from the third column, which is the interesting column, is that the fees at full cost recovery are, first of all, much larger than the actual.
Not in relation to the issue of the EAT, they're not.
Not in the EAT, no. In relation to the.
They breach the Treasury guideline there, don't they?
In respect to the issue fee, but not overall. So the idea is that they will set a scheme which may involve some use of bright lines, but won't recover overall more than the cost of the service. But yes, that particular fee does.
Yeah.
The other point I'd like to draw the court's attention to is just how much more the level 2 claims cost than the level 1 claims, and then how much more again, in particular the hearing fee for the level 3, that the hearing costs are for the level 3 claims. And this makes good the point that the level 2 and level 3 types of claims do use up a lot more resources. And when we come to the justification for the indirect discrimination claim, we rely on these statistics to show that, in fact, the variations between charging type A and type B fees are certainly well justified by the differences in cost. And when one looks at discrimination claims in particular, there's already been an accommodation by drawing them from level 3 into type B and not having a separate type C. How much of the cost is fixed? We saw some of that information earlier, but there's some more. If we go to 6, 7, 8 in the same appendix, that will be 932. Now these are 2010-11 figures. So, my Lord Wilson was correct about the 80 million. It's 84.2 million in 2010-11. 45% of the expenditure was on fixed costs, 55% on variable. As to the explanation as to why to charge for low-value claims at all, the short answer is they're still being provided with a service, and so they should still pay something. The reference for that is Appendix 6, 1751 in old money, 2005 in new money, at paragraph 22, third bullet point. I don't think we particularly need to turn it up. It might be worth, though, looking at Appendix 5 to see how much claims are worth at page 1645. This is a table that my learned friend took to yesterday.
Yes.
New money.
It's that will be 1899.
Yep.
Where one sees the median figures. The reason I revisit this document is that you see there very clearly that if a system was devised by reference to the amount recovered, you would be charging more for discrimination claims than for the other claims.
Yes, I see.
How long do claims take to go through the system? We'll stay with Appendix 5, please. Old money, 1450, new money 1704.
Yep.
This is a summary of how long it takes for cases to go through the system. And I'd like in particular to draw the court's attention to the profound difference between single and multiple claims in the employment tribunal. That is the second and third rows and the last column. The average mean weeks for single claims in employment tribunals at that time last year was 29 weeks. My learned friend gave a slightly different figure yesterday, but that's because it was a different year. The numbers fluctuate in the late 20s between years. And the multiple claims, 221 weeks.
Yep.
That shows you that very different types of case are going through this system, some much quicker than others. And the point I'd make is, if my learned friend on the discrimination point is right, and there has to be a single tier, so there is no statistical disparity in relation to any protected group, not just women, you end up with very different types of cases being charged a single fee, and that, we say, is not a desirable outcome. How many claimants are represented? Page 1464. I'm afraid I haven't noted the bundle number, but I think that will be Appendix 5.
It is.
14.
In old money, 1464. New money will be 1718, I think.
Yeah.
And you see there some statistics on representation, although when I find them myself, I will explain the health warning. It's 1445 is the statistics, 1464 is the definition.
Yep.
1699 for the figure of 84% of claimants are represented by what are called lawyers, and at 1464, which is 1718, there's a definition of lawyer which includes lay representatives as well.
So-called lawyers.
And the representation rates for multiple claimants are even higher. They're 91%. And the reference for that, if you need it, is Appendix 3, page 707, old money, 961, new money.
Is the definition in the footnote at the bottom of 1464? It's not quite all lay members. It's solicitors, law centres and trade associations. Is that where, am I looking in the right place?
Yes, you are,
Yeah.
my lord.
Okay.
Yeah.
Can we now move in file 5 to old money 1645, please?
Back to 1645.
Back to the table. Sorry, I should have made this point earlier.
Yep.
1899 in old money. The point I wish to make is that the medians are well above the fees charged. So when looking at the emphasis that was made by the appellants on people who might find the fees higher than what they are seeking to claim for, it is important to bear in mind that the medians are well above and the means even higher above the fees, and it's also important to bear in mind that claims which don't have a monetary value might in fact be very important. To take an example, if you had a claim of a failure to provide a statement of employment particulars, a simple version of that would be that the particulars simply hadn't been provided, but the content was not in dispute. A complicated version would be a claim that was brought really to get the employment judge to make a declaration as to what the principal terms of the employment relationship are. And if you are, for example, arguing about whether employment is pensionable or what pay is, then a lot of money can flow from a claim which on its face has no pecuniary values. Can we move now, please, to Appendix 6? And I wish to address the proposition advanced yesterday about the remission system and whether applying for remission is head-spinningly complex. At the start of the file, page 1646, old money, 1900 new money is the 2017, the latest version of the guide for help with fees. As you'll notice, it's all written in large text with lots of bold headings. The points I'd like to emphasize start at 1651 old money, 1905 new money. And here is the section about what it is you have to declare in relation to capital. There is a list of things which you should declare with a tick, and a list of things not to include. Conspicuously absent from that list are bicycles, laptops, family jewellery. It's simply not right that you're required to dispose of that sort of object in order to fund an employment tribunal fee. And when we come to the guidance that is provided for staff who have to administer the system, that'll become clear because there are exceptions for household items and also work-related items, and those objects would principally normally fall within the household items exception, failing which, if they were used for work, they'd fall within the tools of the trade exception.
Yep.
The next point is at 1658, 1912 new money, about providing evidence for your income. The paragraph there simply explains that you may get a letter from the court or tribunal asking for evidence of your income. That's because the system has changed from one which required evidence of income to be submitted to one which simply requires a statement of truth and makes plain that you might be asked to prove what you're asserting at a later date, and that makes it simpler. Remissions take-up has been improving, and if we look back in Appendix 5 at 1444,
Yep.
old money, that will be 1698 new money.
Yep.
Under the heading Employment Tribunals, you'll see the statistics there, which had improved by 5% from the year before. These are second quarter of 2016 statistics.
Do you apply for remission online or do you do it in the post? Is there a form?
I think I'm being told you can do both.
Do either, yes.
Yeah. And I think there is a form, isn't there? Yes, there's a form.
But we don't have it in our. We could no doubt find it if we went on the website.
Yep. The guidance I was referring to earlier is back in Appendix 6 at page 1694. And there capital is defined at 3.5 and capital to be disregarded at 3.6. The very first bullet point is that household furniture and contents of the applicant's main or only home fall to be disregarded, and over the page the second bullet point is the exemption for tools and implements of trade, including vehicles. And whilst we're on this document, if we can go to 1707 in old money, that's 1961 in new money, we see the exceptional circumstances guidance for those who administer the system, and it, if anything, rather labours the point that those administering the system must ensure that people who cannot realistically afford the fee must receive the exceptional circumstances remission. The climax of the various exhortations on these 2 pages are the bold underlined words about a third of the way down page 1708.
Any evidence about how long it takes to determine an application for remission?
There is some data on that. I don't have the page references to hand. My diligent junior will find them.
In the interim, some of your applicants will have no money. Some of your applicants, I'm thinking of, did you see the film I, Daniel Blake?
If you mean...
I'm thinking of some of your people who need remission and are entitled to it, but in the interim, they're out of a job, potentially, and they may have no money at all. So it would be quite interesting to know whether it only takes a fortnight to determine an application for remission, or rather longer.
There is some data on that. We can get you the figures, but there was a specific provision in the system to ensure that you can start a claim without having first been granted remission. What you have to do is indicate that you are seeking to apply for remission. You either have to enclose a fee or tick a box to say you're applying for remission. So it doesn't prevent you. Any delay in processing the system doesn't prevent you from lodging your claim. And that was thought important, particularly for limitation purposes.
Thank you.
Moving now to the ACAS study that we've heard something about already. That's folder Appendix 4. The document starts at page 1200, old money, 1654, new money. I'm going to take
1454.
1454. I beg your pardon, my lord?
1454.
1453. Oh, yes, there's the inside cover page, that's right.
Yeah, 1200, right? 1454.
The first point is the date is wrongly given in the index to the contents. The document is numbered 0415. That doesn't mean it was published in April 15. It was in fact published in the summer of 15. I make that point only to explain that it wasn't available to the Court of Appeal.
Yep.
I'm going to take you to some of the detail, but the point I'm trying to make is that the numbers that were being relied upon yesterday and are relied on in the review are the best that can be generated, but they are extrapolations from a questionnaire, and one has to be careful about the quality. And the point made against us is that this is concrete evidence of unaffordability. We say it isn't. It's an extrapolation of people's subjective views about whether they could afford. So the first point is page 1297, old money, which will be 1551, I think.
1297, yep.
1297, section 7.4, decision-making around the non-submission of employment tribunal claims. And you will see there that they're explaining that they were asking in qualitative interviews and a quantitative survey about why people hadn't proceeded to an employment tribunal. 7.4.1 asked why they decided against claiming, reasons set out in 7.4, question asked in an open manner, answers ascribed to pre-existing answer codes. And it's against that background that we need to read the table at the next page, 1298, old money, and top of the list, tribunal fees were off-putting, 26%. The number of people to which this survey applies, unweighted base, 524 people at the bottom. I would ask you to read the text underneath. The middle of the first paragraph of the text underneath contains the sentence, interestingly, responses did not vary by the income of the claimant or by the demographic profile of claimants. However, they did vary by membership of a trade union, with non-members being more likely to report that tribunal fees were off-putting. And this is the passage I said I'd refer to earlier, which makes one appreciate that there isn't a straightforward correlation between income and willingness to pay a fee. It's
Right.
a complicated relationship. As to the question itself, there's no evidence in this study that any measure of affordability was given to those questioned. There was no examination as to whether they'd considered or sought remission or exceptional circumstances.
Yep.
And there seemed to have been a remarkably small number of qualitative interviews. If I can take you to page 1301 in the old money, 1555 in new money.
Yep.
The third, fourth and fifth paragraphs, you'll see there's a reference there to among claimants and representatives who have been unsuccessful, 3/4, 20 out of 29 respondents reported that they would now pay the fee themselves. So we are talking at the qualitative level of the survey of very small numbers. 2 paragraphs below, within the qualitative interviews, that paragraph, if I could invite the court to read that, because what you see is a recording of a complete misapprehension of the fees and cost systems in the employment tribunals. What effectively appears to be being reported is somebody who thinks that the employment tribunals are cost-bearing. Is ACAS early conciliation working? We've touched upon this already. I'll take you to some of the documents, if I may now. It's Appendix Part 5 at 1544.
Yep.
That will be 1798 in new money. And you'll see this is the consultation on proposed reforms. What my client's analysis of the position is. And 114, the position essentially is that there's now a very large number of people using the conciliation service, 83,000 notifications, rising in the last complete year to 92,000. This is a paragraph where you see the figures for the number of people who notify but then don't agree to conciliation. 8,500 employees, 9,000 employers. So the figure for employers is a little bit higher, but not by very much. And at 116, one sees a summary of the ACAS view, which we talked about earlier. 31% obtain formal settlement, 17% do not obtain formal settlement but decide not to submit a claim, reporting that ACAS was a factor in helping them to reach that conclusion. Staying with this file, please could we go to 1550 old money, 1804 new money.
Yep.
And this is the explanation as to why the behavioural objective has, in the view of the Lord Chancellor, been met. And the analysis section, particularly paragraphs 146 to 148, explains the thinking. And the important point to emphasise is we think there is an interaction between early conciliation in its mandatory form and the focusing of attention to the dispute, that having to make a financial contribution to the process if conciliation fails engenders. Is the exceptional circumstances power functioning correctly? My learned friends have taken you to all the figures that are available. Mr. Dowser's witness statement you were taken to yesterday explains why there aren't any earlier figures. This is a case where if the numbers are very low, the appellants say it's not working. If the numbers are very high, the appellants say it's not working.
And if they're very low, you say they are working. If they're very high, you say it's working.
And what I'm going to say is that at this rate, there is nothing to suggest that it's not working. It does appear to be reserved for exceptional cases. Applications are being made, they're being granted. The reasons for them are summarised in the documents you've seen. A quintessential example are people who are in debt, so they haven't got the disposable income which their gross monthly income would suggest. What is the relevance of the difficulties that some claimants have in enforcing their claims? And you were taken this morning to the table which showed what the figures were, with 60-something% of people getting either all the money or part of the money. We submit that the government can provide a system of tribunals, it can provide a system of enforcement. It has studied the figures for enforcement over the years. There are 2 reports in the bundle. Recovery rates are not as high as the government would like to see them, but it has done what it can. It has a fast-track procedure in place for the enforcement of employment tribunal debts. An employment tribunal debt is fed into the county court enforcement system, and to that extent is the same as the rest of the system. There is an issue, though, with employment tribunals, and you see clues as to what it is from the statistics. 37% of those who didn't pay were insolvent. 17% of them couldn't even be traced. And the reality is that when businesses are going under, one of the last things they do is fail to pay their employees and start breaching their rights as the company is in its death throes. And amongst the less scrupulous companies, you have fly-by-night employers who cannot even be found to enforce a remedy against, even if they have any assets. And we say there is only so much the government can do about that. We provide a system where people can bring their disputes and an enforcement mechanism. That the fact you've got to pay a contribution towards using the employment tribunal system and initiating enforcement proceedings should focus attention on whether or not the respondent is going to be good for the money, whether or not you're chasing a man of straw. That is exactly the calculation that litigants in the mainstream courts have to make. And if anything, employees are in a better position, not just because of the fast-track system, but also because of the statutory scheme whereby the National Insurance Fund will meet to an extent, the unpaid debts of insolvent companies. And that is as much, we submit, as can be done, and that it is not, when properly analysed, a factor which means you cannot charge fees or cannot charge them at the rates that are being charged. It's a factor which mitigates towards choosing your respondent with some thought. Moving to the question of hypothetical comparators, these were touched on quite lightly, and I will do the same, but what I would like to direct the court's attention to is the way they were dealt with by the divisional court in UNISON 2. I'm looking now at Appendix 1, page 80. Paragraph 52. This early on in the bundle, I'm not sure whether the page numbers have diverged. It is 334, they have. Thank you. The passage I'm trying to draw your attention to is paragraph 52 of the judgment, and there the court explains why, after argument, the court concluded that the hypothetical comparators could afford to bring claims. The figures were all agreed apart from the rent or the mortgage that it would be reasonable to attribute to a hypothetical secretary and single mother. And the dispute there was between the claimants who said she should be attributed an average mortgage of £540, and the respondents who said a £300 rent would be more likely for someone who was on the minimum wage. The argument was determined on the basis of the appellant's figures, and the only reason I take you to the detail of this is essentially to make the point that far from proving that the scheme was unaffordable, it actually proved on these hypothetical comparators, insofar as one can with a hypothetical comparator, that it was an affordable scheme. Did the review fail to address the wrong question? That was the charge that was raised yesterday afternoon by my learned friend for UNISON. I've already explained why we submit...
I think you mean fail to address the right question.
Or did it
address the wrong question?
I'm sure I did. Sorry. I've already explained why a price sensitivity analysis is, we say, the wrong approach. The approach that has been taken is triggered by the public sector equality duty and the need to have regard to the matters set out under that duty, including the enforcement of discrimination laws and the fostering of good relations, that the falls were a concern, the drop in claims, and something should be done about that. And rather than test out the elasticity of demand, it was decided that the best point at which to apply some more resources was by increasing the thresholds for remission, the thinking being that those who were at the borderline of affordability were those where resources are best targeted. And if I can go in folder 5 to 1557 in old money, please. That will be 1811, I think, in new money. You see the question of falls dealt with. And then at 1585, it's 1839, I think, Chapter 8 of the consultation contains the proposals for an adjusted scheme. And that is what is being consulted on. The present state of play is a consultation is closed. The responses are going to be considered and a decision made. The Minister, subject to the responses, is still minded to make these changes.
So the proposed increase at the moment is, I think, about 15%, isn't it, Mr. Barr?
Yes, if you go to...
On the income side, no change on the capital side.
No change...
If I'm right, more or less about that.
Yes.
The simple question is, how's that been arrived at?
I have got an answer to that one. 1587, there is some science to this one. 1587 in old money, that'll be 1841, I think, in new money. The specific proposal explains that these numbers will bring the figures up to, broadly speaking, the national living wage. And although the genesis of this was the PSED duty, the proposal is that the measure will apply across the board, not just within the employment tribunals, but across the court service.
So you've, in this appeal, got to defend an existing scheme which is, by definition, below the national living wage.
Yes. Yeah. We say national living wage is not the threshold of affordability. Threshold of affordability has been tested, you see, with the hypothetical comparators, with the fact that not that many people are bringing claims for exceptional circumstances. And the analysis is not that. The old scheme was operating unlawfully. The analysis is that it was operating lawfully, but because it was affordable, but it was resulting in a drop in claims which the Lord Chancellor found troubling, and particularly having regard to the need to promote equality. She wanted to make a change, and it was decided, if you're going to do that, make it apply to everybody. So that's the analysis. And you'll see at the bottom of that page the fact that the Lord Chancellor intends to keep the level of fees and remissions under regular review.
Does the application form for help with fees include a box to tick or a box to fill in if you want to say that you should be treated as an exceptional case?
I think the answer, I'll check, but I think the answer is you go through the remissions application first. There are two, if you don't get it, you can appeal. I will just check whether you can go straight to exceptional circumstances or whether you have to go through the remission scheme first. I'm told you can go straight there.
How do you do that? Well, maybe you can answer these really rather vital questions. I'm looking at the form online.
Yes.
It has no box to tick for, do you say that you should get help despite the fact that you don't fall within?
In the document that I showed you earlier, the help with fees documents, I think it does say that you should apply in writing, explaining your position. That's how you actually make it. I do know that is how you actually make it.
Don't put it on the form. It's not there on the form. Yep.
So, my conclusions on ground one, access to justice, is the court below was essentially correct to focus on affordability. It's a preeminent factor, and this is a scheme with no additional barriers to justice of the kind we see in the other cases. I say essentially correct because it has to be remembered in fairness to the court below that this case was argued very differently below. But as put now, the answer remains the same. The scheme is lawful because systematically it does not prevent access to justice. In relation to ground two, the ultra vires claim, we've set out our position in the case. That's at core volume MS 192 to 199. For the reasons we've set out there, we submit that this point doesn't add anything. What really matters is whether access to justice has been denied. Moving on to ground three, which I'll try and deal with very quickly, again, rely essentially on everything which is in our case at MS 199 and following. In relation to variant one, what I should do is address the statistical questions that my learned friend Ms. Monaghan started with this morning. I think it's page 1612 in old money. $1866 in new money, just to be clear about what the disparate impact is. The point that you should really look at in my submission, if you look at table 23, first of all, they add up to 100 in vertical columns.
Yes.
That secondly, the disparate impact that we're looking at is if you compare type A and type B for males, you see a series of percentages which basically show that males are slightly more likely, usually, to bring a type B claim than a type A claim, but there's really not a strong trend. If you look at the female column, and you look at the difference between type A and type B, you'll see that basically about 60%, 62% of women, if you're a woman, you're 62% likely to bring a type B claim and 38% likely to bring a type A claim. So they clearly do bring more type B claims than type A claims. That's not the same as whether the proportion of men and women bring the same proportion of type B claims. If you look at table 22, the right-hand side of it, the year to June 2013, and the figures at 47% of females, 47% of claims for type B were brought by females and 53 were brought by men. That happens to correspond precisely to the proportion of women and men in the workforce. So it was precise equivalence. And the figures have changed a little bit, but not by very much, and that is why the variant 3 claim failed. what falls to be justified effectively is the system of having two fee levels and charging the higher fee for type B. I've shown you the figures which show that discrimination claims cost much more for the service to deliver, that type B claims cost much more for the service to deliver. In short, if you are buying a type A claim, you're buying something rather different to a type B claim. You're buying...
Explain me something about these. Why do the percentages add up more than 100%? You just take 6 months to March 2016, 52% of the claims are by male and 61% are by female.
That's because that table, you should sum it looking vertically. So the 52% of males bringing type B, it's asking what a man does. A man is 52% likely to bring a type B claim and 48% likely to bring a type A claim.
I'm with you. Yeah. Yeah.
And so for the reasons we've explained in our case, we say that it is entirely justified to charge different fees for the different level of service that will, as a matter of generality, be used, and that no alternative has been posited, but all the alternatives are very unattractive. An individual system is overly complicated. A system where you charge according to what's claimed would just make discrimination claims more expensive because they tend to be the most valuable ones. And a single tier system is also unattractive because for those who are bringing simple claims, they would have to pay more than they're paying now. And an inconsistency in the argument we're facing is that is something that the appellants would not want to see happening. A rational division of claims into type A and type B is entirely justified in my respectful submission. As to variant 2, I can't improve on the reasoning of the two very experienced employment lawyers who dealt with this point in the UNISON 2 case and in the Court of Appeal, both of whom are past presidents of the EAT. I submit that they correctly analysed that the wrong comparison was being made. You should look at all of those to whom the type B fees are applied. If I'm wrong in that, then the division is justified for essentially the same reasons as the variant 1 claim. Finally, remedy and costs. I've already dealt with some questions to this effect. The submission from my learned friend yesterday that you should simply decide whether it's lawful or not and give no assistance whatsoever to the Lord Chancellor in her endeavours if you find against her to run a lawful system is, in my respectful submission, entirely helpful. What the court is respectfully invited to do, if the court finds against the Lord Chancellor, is to give as much guidance as possible as to the scope of lawful action. And as I said before to my Lord Wilson, in the first instance we would ask for time to correct any error. There is a wider programme of work going on about fees in the court system in general, and that is an additional reason why it would be especially helpful if the court is against us to have as much guidance as possible. I would ask the court to consider that this is a scheme which is only coming up to 4 years old. I've got a reference for the case of Seymour Smith. It's Authorities Bundle 6, tab 84 at 262C to E, where you see the court there explaining that it is, in some circumstances, reasonable to give systems time effectively to bed in and for the government to establish how they're working and whether they need changing. That was in the context of the qualifying time limit for unfair dismissal claims. In that case, 6 years was said at that point in the judgment, not to be, well, not to be long enough for the court to intervene. Those are, unless there are any questions about remedy, my submissions on remedy, and my submission on cost is simply, might we be permitted to make written submissions?
Yes, of course. Thank you very much indeed. Thank you. Ms. Rose.
My lords, my lady, can I deal first with the legal test? The respondent's case is premised on the argument that court fees should be treated differently from any other kind of interference with Article 6, and uniquely should not attract the normal analysis that applies to all qualified convention rights, namely that where there is an interference with the right, that interference will be unlawful either if it breaches the essence of the right or if it is not shown by the defendant to be a proportionate means of meeting a legitimate aim. Instead, they say that uniquely in the context of court fees, the test to be applied is not whether or not the right is restricted, but whether the right is absolutely denied by what they described as an insuperable barrier. No reason in principle has been offered by the respondent for why court fees should be treated differently from any other kind of interference with the right of access to justice. That proposition, in itself a remarkable one, is not supported by any of the case law to which the respondent has referred the court. Not only that, it is contrary to the express terms of Article 52 of the EU Charter on Fundamental Rights, because Article 52 makes it quite clear that interferences with any of the substantive rights in the Charter, including the right under Article 47, will be lawful only where they are proportionate and where they respect the essence of the right. Essentially, the approach taken by the respondent collapses the question of whether there is a breach of the essence of the right into the question whether there's been a fair balance applying a proportionality test, and seeks to require the court to grant a remedy only in the first case. We say that's wrong as a matter of principle and is not mandated by any of the case law. So far as the common law is concerned, Leach was not a case of an absolute barrier or an insurmountable obstacle to access to justice. That was the whole point of the analysis to which I referred the court yesterday. And Mr. Justice Laws, when addressing Leach specifically in the Witham case, said in terms, this case, Witham, is a fortiori Leach, because in Leach there was not an absolute barrier on the right of access to justice. He didn't say, of course, in this case, there would only be relief given in circumstances such as this, where there happens to be an absolute barrier. He simply noted that that was a factual distinction between Leach and the case he had to deal with. In Witham, because there was no provision for the remission of fees, there was an absolute barrier. But that doesn't mean that an absolute barrier is a necessary condition to find a breach of the constitutional right of access to justice. And the relevant passage in Mr. Justice Laws's judgment is at Authorities Bundle 1, tab 9, and it's page 2308, where he makes that point. The Court of Appeal in Hillingdon, of course, expressly rejected the submission that the test was one of whether or not the local authority was obliged or required not to bring the claim, and instead said the question is a factual one. Will claims that objectively ought to be brought not be brought? In other words, the test is deterrence in fact, not inability in principle. And we say that the same language is apparent throughout the Leach case. So we say that's clearly the position at common law. And in a sense, that's all that matters. Because one thing that is abundantly clear is that neither the case law of Strasbourg nor of the European Court in Luxembourg could reduce the level of protection which the common law grants to the right of access to justice. Strasbourg is a floor and not a ceiling. But in fact, we see exactly the same approach both in Strasbourg and in Luxembourg. Of course, it's right that many of the Strasbourg cases, on their facts, are about affordability. It is clearly a relevant requirement and is treated as such, and it's clearly sufficient. But there is no case, as Mr. Ford rightly pointed out, there is no case that says it is a necessary requirement. And calling cases in which there isn't an affordability issue outliers, with respect, is no answer to the appellant's case. So far as the EU case law is concerned, the DEB case at volume 3, tab 31, what was said by the respondent was that that case was dealing with principles applicable to legal aid. With respect, that's not correct. If we just turn it up very briefly, volume 3, tab 31, the relevant paragraph is 47, which Ms. Wakefield did not show the court. It's at page 2834. She showed your lordships and your ladyship paragraph 46, dealing with the principles relating to the case law concerning legal aid, and said, look, that's what this case is about. But in the following paragraph, the court went on, as regards legal aid in the form of dispensation from payment of the costs of proceedings or from provision of security for costs before an action is brought, the European Court of Human Rights has similarly examined all the circumstances in order to determine whether the limitations undermine the very core of the right and whether there's a reasonable relationship of proportionality, and citing Tolstoy, Miloslavsky and Kreutz. So with respect to Ms. Wakefield, she is simply wrong about DEB. So far as the Orizzonte case is concerned, as I understood it, it was suggested by Ms. Wakefield that the court in this case wasn't applying a proportionality approach at all. Well, if that were right, then the Orizzonte case, with respect, would be clearly defective, because it's abundantly obvious that Article 47 does require a proportionality approach under Article 52. In fact, it's clear from the Advocate General's opinion, paragraphs 41 to 43, which Mr. Ford showed the court, that the proportionality approach was being applied. The court judgment is tersely expressed, but in substance, it is a proportionality approach. The most recent Luxembourg case is Star Storage at volume 3, tab 35, and it is very clear in that case that a proportionality approach was being applied in its full orthodox sense. And one sees that both from paragraph 55 of the judgment and from the paragraphs of the Advocate General's opinion of Advocate General Sharpston. Then finally, looking at the Coote case, what Ms. Wakefield said, this is at 329, what she said was that this case was about an absolute barrier to the court in order to bring a victimisation claim. With respect, that is a complete misunderstanding of Coote. The whole point about the Coote case was this. The European directive, the Equal Treatment Directive, did not require any remedy for victimisation post-termination. That was not a requirement that member states were required to impose under the directive. All that the directive required was that there should be a prohibition on discrimination in employment and a prohibition on a dismissal, which was an act of victimisation. That was Article 7 of the directive. And what the directive also required at Article 6 was that there should be an effective right of access to court in order to vindicate the rights in the directive. And what Ms. Coote was arguing, and the argument was accepted by the court, was that a prohibition on victimisation after the end of employment was necessary, not because the directive required that, but because in its absence, employees would be likely to be deterred from going to court to enforce their rights not to suffer discrimination, for fear that they would suffer retaliation after the end of their employment. And that was the point of paragraphs 24 to 27 of Coote, which I showed the court yesterday. Coote is decided solely on the basis that the absence of such a right, even though not expressly required in the directive, is a deterrent, not an absolute bar, but a deterrent on the exercise of the right of access to justice. and it required the United Kingdom to introduce a new substantive cause of action in order to supply the deficiency. Now, that is a very significant judgment. Firstly, because it demonstrates the deterrence test, not the absolute barrier test. Secondly, because it shows the potency of the requirement of what Mr. Ford called the effet utile principle, that there must be the effective enforcement of fundamental rights at European law, including the right to equal treatment. And thirdly, because of the stress which the court laid in Coote on the social benefit of the enforcement of the right to equality, which has always been regarded by the European institutions as desirable, firstly, for reasons of social justice and equity, and secondly, for economic reasons, because if the right to equal treatment is not effectively enforced, there is not a level playing field, and you get what is often called social dumping, that territories or employers who have bad employment practices gain a competitive advantage over territories and employers that have good employment practices. And that point is being emphasized in Coote as well. Now, it was very striking in my learned friend's submissions to the court today that he did not respond at all to the point I made yesterday about the failure by the government to attribute any value whatsoever to the necessity and the desirability in social terms of the effective enforcement of employment rights, including not just equality rights, but all of the relevant employment rights which can only be enforced through employment tribunals. That the value attributed to that was nil. He has chosen not to address that argument at all. And in our submission, that is a significant defect in the government's case, because given the very modest positive benefit which this scheme has given rise to, an income of something, a net income of something around 7 million a year when you take into account the costs of implementing the scheme, attaching any value at all to the social benefit of the proper enforcement of employment rights would lead to the conclusion that this scheme is actually a burden on the public purse and not a benefit. And it's never been evaluated, and there has been no explanation from the defendant of why not. Turning then to the facts, it was complained by my learned friend that we raised the point that the higher fee didn't equate to more money in our oral submissions. Well, the answer to that is very simple, and it was given by my Lord Wilson. We were responding to a point that was taken by the respondent in their written case. It was the respondent in their written case who said, we rely on the fact that there is no less onerous means of meeting our primary financial aim, because the lower the fee, the less money will be collected. And it was the fallacy that was included in that paragraph which gave rise to our argument. And it appears that they maintain that fallacy in a situation where they have made no attempt to model the question. Now, what was conceded by my learned friend was that at the time that the policy was originally introduced, it was introduced in the erroneous belief that claimants in employment tribunals were unlikely to be price sensitive, based on the 2007 survey dealing with certain categories of civil litigants. And they modelled it on the alternative scenarios that every £100 in fees would cause a 1% fall in the number of claims, or that every £100 in fees would cause a 5% fall in claims. We know that those projections are massively out, that in fact the falls have been somewhere closer to 70% from fees of about £200, £250, the issue fees. No. Now, the point is this, that when they conducted their review, they had the data. They knew that claimants had been enormously price sensitive, and they knew that as a result, they were not collecting anything like the contribution to costs that they had projected. And the court will recall that we looked yesterday at the section in the review where they said, we acknowledge that we haven't collected anything like a third of the costs. And the reason is, first of all, we were wrong about the level of remission, and secondly, we were wrong about the level of fees. And it's at that point that they should have said, well, hang on a second, maybe the fees are inefficiently high. My learned friend says, oh, well, there's no evidence that we've passed the profit maximising point. But the onus is upon the respondent to provide that evidence. And in fact, there is a strong prima facie suggestion that that is so because of the massive drop in demand. Any service provider who sets their price at a level that causes a 70% drop in demand for their product is likely to think, oh, maybe I've set the price too high and I've killed the market. And saying it's all very complex, with respect, is no answer to the point. So far as the county court is concerned, my learned friend rightly makes the point that we have given the court the fees for small claims, claims up to £10,000. And of course, we did that for two reasons. First, in order to illustrate the particular problem that the fee structure under the Employment Tribunal scheme presents for low-value claims, where the fees are utterly disproportionate and result in no rational person bringing a claim. And secondly, because that is a matter of great importance, given the statutory purpose of the Employment Tribunal system and of many of the rights enforced through it. And you will recall our original note that we handed up yesterday, identifying specific statutory rights. Now, I just want to identify one here, which is a claim for a statement of reasons for dismissal. It's at paragraph 2.4 of our note. This is sections 92 and 93 of the Employment Rights Act 1996. Yep. And if the court looks, I'm afraid it's not in the bundle, but easily found online. If the court looks at section 93 of the Employment Rights Act, what it says is that a complaint may be presented to an employment tribunal by an employee on the ground that the employer unreasonably failed to provide a written statement under section 92, or that the particulars of reasons are inadequate or untrue. Where a tribunal finds a complaint well founded, the tribunal may make a declaration as to what it finds the employer's reasons for dismissing the employee were, and shall make an award that the employer pay the employee a sum equal to the amount of 2 weeks' pay. Now, that's very significant because that is primary legislation in which Parliament has said there is to be a right which can only be enforced in an employment tribunal and for which the only remedies that may be given are 1, a declaration, and 2, an award of 2 weeks' pay. And this is the burden of ground 2, that our submission is that it is unlawful for the Secretary of State, by delegated legislation, by secondary legislation, to introduce a fee scheme which makes the effective enforcement of that right wholly uneconomic, regardless of whether you can afford to pay or not. For most people, such a claim is now futile. It's still on the statute book, but it cannot be enforced. And that's the key point under ground 2. And in my submission, that point applies with still greater force when you consider it in relation to claims that are implementing European rights, such as the right to paid time off for antenatal care, the right to rest breaks, working time claims, holiday pay, and so on. Because those are claims where the Coote principle is in full play, as well as the principle from JCWI, that you cannot use secondary legislation to frustrate the purpose of primary legislation. So far as the question of engagement with ACAS and settlement rates is concerned, I showed the court yesterday the evidence that shows that there has been no improvement in the rate of settlement. On the contrary, the rate of settlement has fallen. In relation to employers' engagement with ACAS, there is some evidence on this. If we take up Appendix 5, page 1809, that's the MS number. The internal number is 1555.
Yep.
Paragraph 174, this is from the review. There is some evidence from ACAS that some employers are not prepared to engage in conciliation, which some commentators have suggested may be a tactic to see whether the employee is prepared to pay the fee. We continue to believe it's better for parties to try to resolve their differences through conciliation. We accept it's ultimately a matter for the parties. So they record the fact that there is evidence that employers are not engaging and that it's been suggested this is a tactical consideration because the fees give them an extra negotiating advantage, and they have no answer to the point at all except to continue to assert their belief that everything is fine. The £3,000 is now conceded to be an arbitrary figure that has no underpinning. The test for the systemic challenge, the court already has my submission that the test is not the Christian Institute test, which is properly applicable when you're looking at individual exercises of discretion. The test is the test from detention action. Is this a systemic, disproportionate problem that's not related to aberrant decisions? It was suggested that a large number of claimants were legally represented, but the figures that were being shown to the court related to multiple as well as individual claimants. And of course, in a lot of multiple claims, there will be representation. The figures for individual claimants are at Appendix Part 2, page MS 794, that's 540 in the internal numbering. And you will see that they are much lower, particularly for certain types of claims. If you go to, yes, 794.
Yep.
So this is 2013 findings from the Survey of Employment Tribunal Applications.
Yep.
This is individual claimants. And if you look at the bottom paragraph on the page,
Primary jurisdiction, yeah.
you see representation most common in discrimination cases among claimants, 61% of claimants represented in discrimination claims, but then in Wages Act cases, only 33% of claimants represented. And there are further statistics given over the page, so much, much lower figures for representation. The remission scheme, so far as the complexity is concerned, if we just go back to Appendix Part 6, page 1908, I invite the court to read the guidance between 1908 and 1911.
This is MS 1908, is it?
Yes, the internal numbering is 1654 to 1657.
Yes.
And I simply invite the court to read that. It is extremely difficult to understand. The oddity about non-financial property is it's not mentioned on either the included capital list or the excluded capital list, even though the regulations say it's included as part of your disposable capital.
Yep.
The form does not say anything about exceptional cases remission. There's nothing on the form. Now, so far as the evidence on affordability is concerned, you were shown the Appendix Part 4, page 1298. Let's just turn this up. (1298) on the internal numbering.
Yep.
Relating to claimants saying that the tribunal fees were off-putting and points being made about how that doesn't tell you the reasons why they were off-putting. But the reason is that Mr. Barr didn't show you the following page, 1299, 1553 in the MS numbering.
Yep.
Claimants and representatives who reported that tribunal fees had been off-putting were asked why this was. This question was asked in an open manner, but responses were attributed to a set of pre-existing answer codes, and then we see that 68% said they couldn't afford the fee, then 19% fee was what I was prepared to pay, value of the fee equaled the money I was owed, I disagreed with the principle of having to pay the fee. So those are the reasons that were given. So in fact, this is pretty good evidence because open questions are being asked, and a range of different responses are being given. It's also, of course, the best evidence and the evidence on which the respondent has herself relied. In relation to the remission scheme in general and the exceptional circumstances power in particular, my learned friend said, well, there's nothing to show it's not working. With respect, there is indeed something to show it's not working, and that is the 68% fall in tribunal cases and the 8,000 people in 1 year saying that they haven't pursued a claim, even though they haven't been able to settle it because they couldn't afford to do so. That shows you that the scheme is not working, as against 31 remissions for exceptional circumstances. So far as enforcement is concerned, my learned friend gave us a useful lecture on how it's not a good idea to sue people who are insolvent. But the fact of the matter is that the majority of the employers who didn't pay, something well over 60% of them, were solvent, but were still not paying. So far as the hypothetical scenarios are concerned...
I think his point was that's not the Lord Chancellor's fault.
Indeed, it's not, my Lord. But given the difficulties of enforcement, that's relevant to the question of whether these fees are a barrier to the effective enforcement of individual rights, because it's a factor that people will take into account when they decide whether there is any purpose at all in going to an employment tribunal.
Or on the basis that these figures are public, so solicitors are deemed, or people are deemed to know them, are they?
Yes.
I think it's...
Well, even if people don't know the precise figures, they will be aware of the fact that an employment tribunal award has got to be separately enforced through extra proceedings in the county court, which themselves incur a further fee.
No, the fact that it's got to be enforced is one thing. The fact that they may not be good for the money or manage to evade paying.
Yeah.
It's quite a difficult point whether that should be taken into account, isn't it?
Well, I think previously you put it as to some extent neutralising the response that the fees were recoverable.
Yeah, that's right. That's right.
Yes. As far as
Now, the hypothetical scenarios, my learned friend showed you page 335, the extract from the first instance judgment. Now, what that showed was the court saying these cases are affordable in cases where people were being asked to spend 80% of their monthly income on the employment tribunal fees. Now, that in a situation where ex hypothesi people have either no savings at all or savings below £3,000, and where they may be expecting a baby and they may be unemployed so that it's their partner's income, which is now the sole family income. And on the basis that their disposable income is after considering only essential needs, which don't include things like clothing. And when you come to consider the fact of somebody who's just lost their job and you ask, well, is it essential that they have a pair of shoes to keep their feet dry? Or is it essential that they have a pair of shoes that are smart enough that they can wear to a job interview? It becomes an extremely difficult question. Ultimately, what shows you the deterrent effect of this scheme is the effect that it has actually had in the real world, where meritorious claims are not being brought. The oddity about the way that my learned friend put his submissions, with respect, is that he has not addressed our case on proportionality at all. He made no submissions to this court about the extent to which the aims that were identified in the review as being the aims of the legislation have actually been met, or about the question of fair balance. He made some submissions on the facts, but he hasn't really responded to our case on proportionality. In summary, for all the reasons that we've given in our written case and orally, we invite the court to allow the appeal. In relation to relief, can I just say that we would invite the court, if the court is minded to allow the appeal, to give us an opportunity to make written submissions on relief as well as on costs, because there are obviously different permutations.
Seems to us that that's a sensible course to take.
Oh, yes. Mr. Ford invited me to draw the court's attention to the note that he handed up this morning about exemptions. Yes?
Yes, my lords, it's, and my lady, it's simply explaining the proposal in the review to exempt the National Insurance Fund claims from fees, what that actually covers. Because it doesn't cover, it only covers principally redundancy and unfair dismissal, so it has almost no effect in relation to even guaranteed rights.
Mr. Barr's seen that, has he?
I've seen it, my lord, but I've not had time to read it.
Well, if there's anything that you don't agree with if there's anything in it you don't agree with, then you'd better let's have a copy of a note in writing explaining what you don't agree with.
Thank you.
Obviously giving copies to the other parties. And how long do you take? You do that by next Monday?
Yes.
Good. Hopefully by the weekend. Good. Thank you. Very well. Well, we're very grateful to all 5 of you for your submission. Thank you very much indeed. We are also very grateful to all those who are involved in preparing the written cases, which we found very helpful, and to all of you also for getting through this case with quite a lot of written material, both actual and authorities, in the time allotted. Thank you all very much indeed. We'll consider our decision and let you know in due course. Thank you very much. Court's now adjourned.